Hello friends, welcome back to a new video. So friends, today in this video I am going to share with you the topic of principles of natural justice, which is one of the component of the subject administrative law. So let's see, in this video we will cover the principles. Like these are basically two forms, like nemo judex in sua causa, that is rule against bias, and the second main principle is Audi Alteram Partem. So before going further, let we see the general meaning of the principles of natural justice. So in the case of R.S. Das versus Union of India, the Supreme Court stated that it is well established that the rules of natural justice are not a rigid rules and they are flexible, and their application depends upon the settling and background of statutory provisions, nature of the right which may be affected, and the consequences which may be entailed, and its applications depends upon the facts and circumstances of each case. The concept of natural justice entails basically two principles, that is nemo judex in causa sua. In general meaning, it can be said that no one shall be the judge in his own case, or the deciding authority must be impartial and without bias, that is rule against bias. And the second principle of natural justice is Audi Alteram Partem, that is here the other side or both the sides must be heard, or no man should be condemned unheard, or that there must be a fairness on the part of deciding authority, that is rule of hearing or fair hearing. So the first one is rule against bias, that we will discuss in a detail for the examination purpose, because in shortly we can see that the no one shall be the judge in his own case, but how it can be contended or concluded in view of from the law point of view. So first of all, the rule against bias is the first principle of natural justice, is the rules against the bias. It means that the deciding authority must be impartial and neutral. It is based on three maxims, that is no man shall be the judge in his own case, and the justice should not only be done but manifestly and undoubtedly be seen to be done, and judge like Kaiser's wife should be above suspicion. Now what this principle says, it explained that it is a well settled principle of law that justice should not only be done but must be appear to be done. Justice can never be seen to be done if a man acts as a judge in his own case or is himself interested in its outcome. This principle is applicable not only to judicial proceedings but also to quasi-judicials as well as administrative proceedings. If the judge is subject to bias in favor of or against either party to the dispute, or is in a position to that a bias can be assumed, he is disqualified to act as a judge in that particular case, and the proceedings will be vitiated. Now what are the types of bias? Because bias may be of different kinds, that is in the form of pecuniary bias, personal bias, subject bias, departmental bias, and or policy bias. So now what are these five heads? So first head is pecuniary bias. As regards the pecuniary bias, the least pecuniary interest in the subject matter of litigation will disqualify any person from acting as a judge. According to Griffith and Street, a pecuniary interest, however slight, will disqualify even though it is not proved that the decision is in any way affected by it. In the case of Manaklal versus Premchand, it was observed that it is obvious that pecuniary interest, however small it may be in a subject matter of the proceedings, would wholly disqualify a member from acting as a judge. Again, in the case of Jijabhoy versus Assistant Collector, the bench was reconstituted on the objection that one of the members of the bench was member of the cooperative society for which the land in dispute had been acquired. The second main important kind of bias is personal bias. Personal bias arises in a number of circumstances involving a certain relationship equation between the deciding authority and the parties which inclined him unfavorably or otherwise on the side of one of the parties before him. Here, a judge may be a relative, a judge may be a friend, or a judge may be a business associate of any of party. He may have some personal grudge against him, enmity, or grievance, or professional rivalry against such party. And in view of these factors, there is every likelihood that the judge may be biased towards the one party or prejudicial towards the other party. So this is the personal bias. Let me see with the help of one of the case law. In the case of Mineral Development Limited versus State of Bihar. In this case, the petitioners were granted mining license for 99 years in the year 1947, but the ministers who had political rivalry with the petitioners cancelled the license. The challenge was accepted by the court, and it was held that there was personal bias against the petitioners and the ministers was disqualified from taking any action against the petitioners. Now the third bias is subject matter bias. This may arises when the judge has a general interest in the subject matter of the proceedings. According to the Griffith and Stitt, only fairly will be the bias invalidate proceedings. A mere general interest in the general object to be pursued would not disqualified as a judge from deciding the matter, and there must be some direct connection with the litigation of the subject matter. Only in that case it can be said that the subject matter bias arises in a very particular proceedings. Third is departmental bias. Departmental bias is inherent in administrative process. If it is not checked, it will negate the concept of fairness in administrative process. In the case of State of UP versus R.S. Sodhi, the question was whether the state police should investigate into the alleged fake encounters. Allegations were leveled against the local police. According to the Supreme Court, investigation into the matter by independent agency was desirable, and accordingly the court directed CBI to investigate into the allegation. The last form of bias is policy bias. Sometimes it happens that the ministers or the officers concerned may announce beforehand the general policy which he intends to follow. The question is whether such a statement would disqualify him from acting as a deciding authority on the ground that this indicates his partiality to the issue in disputes. So according to Professor Wade, ministerial or departmental policy cannot be regarded as a disqualifying bias. So now we see the principle of Audi Alteram Partem, rule of hearing, or we can also say it like a personal hearing. This is the second principles or components of the principles of natural justice. So the meaning of Audi Alteram Partem provides that the hear the other side, or no one should be condemned unheard, or both the side must be heard before passing any order in a particular case. In a civilized society, it is assumed that a person against whom any action is sought to be taken or whose right or interest is being affected shall be given a reasonable opportunity to defend himself. It is the first principle of civilized jurisprudence and is accepted by the laws of man and God. In short, we can say this principle is that before an order is passed against any person, a reasonable opportunity of being heard must be given to him or afforded to him. Generally, the maxim includes two elements. The first is notice and the second component is hearing. So, first component, that is notice, provides that a basic principle of natural justice is that before any action is taken against anybody, the affected party must be given a notice to show cause against the proposed action and seek his explanation. It is a sine qua non of the right of a fair hearing, and any order passed without giving a notice is against the principles of natural justice and is a void ab initio. Now, only the notice is issued is not a very enough. Its adequacy is also required, because it is not enough that a notice in a given case be given, but it must be adequate also. The question of adequacy of notice depends upon the facts and circumstances of each case. It can also be said that the reasonable opportunity must be given. It is to be noted that the notice must be given a reasonable opportunity to comply with the requirements mentioned in it. By only giving a 24 hours time to dismantle a structure alleged to be in a dilapidated condition is not a proper time, or the notice to be declared is not as a void. Second is hearing. The second requirement of the Audi Alteram Partem maxim is that the person concerned must be given an opportunity of being heard before any adverse action is taken against him. In the case of Menka Gandhi versus Union of India, the passport of the petitioner was impounded by the government of India in public interest. No opportunity was afforded to the petitioner before taking the impugned action. The Supreme Court has held that the order was violative of principles of natural justice, because no opportunity was afforded to the petitioner before taking any action against him. In the case of Sridhar versus Nagarpalika, the petitioner was appointed by the municipality as tax inspector. The commissioner set aside the said appointment without issuing any notice or giving an opportunity of hearing. The Supreme Court quashed the order of the commissioner and observed that it was an elementary principle of natural justice that no person should be condemned unheard. Now, this is also covered in two forms, like oral hearing or fair hearing. Oral hearing means a person cannot claim the right to oral or personal hearing unless such right is conferred by the statute itself. In the absence of such statutory requirement, the general rule propounding by the Supreme Court of India is that the natural justice does not necessarily involve a right to a oral hearing. Second is fair hearing. While fair opportunity to be heard should be given to the parties, the principle does not imply, unless expressly provided by the statute, a right to a personal hearing. The requirements of a natural justice are not only if opportunity to represent is given in view of the proposed action. So now, what are the requirements of a fair hearing? Again, a fair hearing requires the following rights, some rights which must be given to the person affected by it. So the first, how a fair hearing can be decided is the proper way of. First point is cross-examination. Cross-examination is one of the most efficacious methods of establishing truth and exposing falsehood, but it does not necessarily mean that the right of cross-examination of witnesses is upon the facts and circumstances of each case and to the statutory provision. Second is legal representation. Normally the right of a representation by a lawyer in any administrative proceedings is not considered to be indispensable part of natural justice, as oral hearing is not included in the minima of fair hearing. But speaking generally, it can be said that the right to be personally presented by the counsel has been recognized in the administrative law. Third point is right to know evidence. The right to know the materials on which the authority is going to make a decision is a part of the right to defend oneself. The general principle is that the adjudicating authority must base its decision on the material known to the parties. No evidence can be taken into considerations which has not been known to the parties concerned and for which no opportunity has been afforded to rebut it. The last important component of fair hearing is the opportunity of being heard. The requirement of the opportunity of being heard is a very part of the fair procedure, and any order passed by the adjudicating authority without providing any opportunity of being heard to the party concerned is a bad and can be set aside by the adjudicating authority. So we can say that the opportunity of to be heard must be required two things, that is the opportunity must be given and the opportunity must be reasonable. Thus we can say that the reasonable opportunity of being heard should be provided. But in this video we see the basically two principles of natural justice, that is rule against bias and the principle of Audi, Alteram, Partem. Now here are some exceptions to the principles of natural justice which cannot be covered in the situation or scenario that I am going to share with you. So then some of the following cases is the first one where the principle of natural justice is not applied is where a statute either expressly or by necessary implication excludes applications of natural justice. That means there are some situations or scenarios where it has been specifically excluded or included that in that cases the principles of natural justice will not apply. Second one is where the action is legislative in characters and the plenary and subordinate. Third one is where the doctrine of necessity implies, and the fourth is where the facts are admitted or undisputed, where the inquiry is of a confidential nature, where a preventive action has been taken, and where a prompt and urgent action is necessary, where nothing unfair can be inferred by a non-observance of natural justice. So what we has been discussed in this video, we can say that the one thing which has to be noted, that the inference of exclusion of natural justice should not be readily made unless it is irresistible, since the courts act on the presumption that the legislature intends to observe the principle of natural justice and those principles do not supplant but supplement the law of the land. Therefore, all statutory provisions must be read, interpreted and applied so as to be consistent with the principles of natural justice. So this is the entire video. It may become a very lengthy, but it covers the entire videos and concept regarding the rule against bias, nemo judex in sua accusa maxims, and the second one is Audi, Alteram, Partem. So friends, I hope you like this video. Please don't forget to subscribe it, like it and share it with others students so that they will get the useful information. And if you need any notes regarding this topic, you may also contact me so that I will help for you regarding your exams in LLB course or other course as the case may be. So friends, see you with some other topics. Thanks for watching this video.